Yeah.
Thank you, Mr. Kisan Goswami. Now, I requested Mr. Kaushalya Navaratnam to give his speech about mediation in Sri Lanka. Mr. Kaushalya Navaratnam, former President, Supreme Court Bar Association of Sri Lanka and President's Council, is already joined with us online.
মানে সাউন্ড যাবে না সাউন্ডটা দাও সাউন্ডটা দেন
Can you all hear me?
Yes, sir.
Yes. Thank you very much. Your Lordship, Justice Ahmad Sohail, Justice Khas Azad, distinguished resource personnel, office bearers of the Mediators Forum and the Lawyers Guild Bangladesh, my colleagues at the bar, and dear participants. Good morning to everyone. And firstly, I must extend my heartfelt gratitude and sincere thanks for the invitation extended. And I consider it to be a great privilege to be a part of today's program. And in fact, from time to time, Dr. George was contacting us and was in discussion with regard to the evolvement of the alternative dispute resolution mechanisms back in Sri Lanka. And various occasions, the invitations were extended to us to share some thoughts, especially the local procedures back in Sri Lanka with the international community and our colleagues back in Bangladesh. Therefore, I take this as a great opportunity and a privilege and honor to share some thoughts with regard to the legislative processes and the provisions that are applicable back in Sri Lanka regarding mediation, especially the mediation being considered as one of the most cost-effective and efficient alternative dispute resolution mechanism back in our jurisdiction. Ladies and gentlemen, if I may touch upon certain relevant facts and factual positions back in our jurisdiction, there are many concerns that have been expressed over a period of time regarding loss delays. Because when we conducted certain surveys and in order to ascertain what sort of effective measures should be taken or other steps should be taken to address the loss delays back in Sri Lanka. And one of the main areas that was taken cognizance of or rather taken into consideration by the relevant authorities to introduce the new mechanisms, especially with regard to the cost effectiveness and the time management, and to resolve the disputes which have got piled up in courts. Because in terms of certain international the criteria when we looked at it, there was sometimes ago, like a few years ago, they have recognized that in order to enforce a little agreement between parties, it takes more than 1,000 days in Sri Lanka. So therefore, in terms of the international rankings, we were not considered as one of the best destinations by the international investors to make investments in Sri Lanka. So therefore, this was a going concern, and therefore the various governments and the architects took various steps to address these growing concerns. So in this context, this mediation has now become one of the most sought after the mechanism of resolving dispute in Sri Lanka. So, ladies and gentlemen, having said that, if I will, I have been informed the time concern. I'm quite conscious of the fact that I have been given a very specific period of time within which I will endeavor to kind of detail out and to discuss with you the legal provisions that are applicable in Sri Lanka vis-a-vis the mediation. As I mentioned to you earlier, our economy is mainly concentrating on investments. We are seeking the foreigners and the foreign investors, the businessmen, to come and invest in Sri Lanka, and it's quite well known. We have gone through certain economic crisis, a few years ago, and we are just trying to come out of it. And therefore, even in compliance with the demands made by certain international organizations, especially the IMF, we were compelled to discuss these important issues, especially with regard to the resolution of dispute among the community, especially the investors as well. So therefore, the ADR systems, that is the alternative dispute resolution mechanism, one of the most sought after or rather discussed topic among the legal community and the stakeholders. So in that context, we were concentrating on adjudication, arbitration, of course, one of the most popular ADR mechanism in this part of the world, and the Sri Lanka is whilst setting up certain special laws through the parliament, we are trying to be one of the most popular destination like Singapore and many other countries regarding arbitrations, and we are just trying to make Sri Lanka a hub for international arbitrations. Therefore, we are in the process of setting up certain infrastructure and the legislative mechanisms to meet the international standard in that context. So, and the next popular ADR system in the country is mediation. Ladies and gentlemen, firstly, the topmost priority, or rather the much sought after dispute resolution mechanism, was the arbitration. So we set up by way of a special statute. Hopefully, we are just trying to bring, we are advocating with the respective stakeholders to introduce a clause in the agreements when they enter into even international agreements related to mediation, so that the issues could be resolved between the parties in the event, if any, through mediation is a very cost-effective manner, which is the cost factor is something which we are paying much attention to. So thank you very much for the Mediators Forum and the Lawyers Guild of Bangladesh, and my friend Dr. George Victor, for extending an invitation to share some thoughts on this very timely topic of the involvement or an evolution of mediation instead of the usual litigation, the court litigation in our jurisdictions. Thank you, Lordships, for the patience hearing and for all the participants, and I hope that I have shared something with you, and certainly I'm looking forward to travel with you in future, so that I will hopefully share some more thoughts on this subject at your request. Thank you very much.